Welcome to Neo Nexus. Subscribe and hit the bell icon for updates. The Supreme Court issued a stunning 8-1 emergency order, allowing the Trump administration to proceed with mass federal layoffs. Justice Ketanji Brown Jackson's lone dissent has sparked fierce debate over presidential power and the future of the civil service. The order lifts a lower court's injunction, letting the administration move forward with a February executive order directing agencies to prepare for sweeping reductions in force. This decision is a pivotal moment, raising urgent questions. Can a president unilaterally dismantle the federal workforce, or is this an overreach of executive authority? As we break down this case, we'll explore the executive order's background, the legal arguments, and the far-reaching implications for American governance. To understand the court's decision, let's clarify what an emergency order is. These orders, part of the Supreme Court's shadow docket, are fast-track decisions made without full briefing or oral arguments. They're typically used when urgent government requests seek to block or allow lower court rulings while appeals play out. Critics argue the shadow docket lacks transparency and thorough legal reasoning, while supporters say it's vital for urgent corrections. In this case, after lower courts blocked the layoffs, the Trump administration turned to the Supreme Court, claiming the injunction was causing severe harm. By granting the emergency request, the court signaled that the administration's arguments were strong enough to warrant immediate intervention, drawing both praise and criticism. The controversy began on February 11, 2025, when President Trump signed an executive order directing all federal agencies to prepare for large-scale layoffs. The order empowered the new Department of Government Efficiency, DOGE, to oversee the process, aiming to shrink the federal workforce dramatically. This move followed earlier firings of over 20,000 probationary employees, but now targeted the broader, permanent civil service. The administration argued this was about efficiency and accountability, while unions and watchdogs saw it as a politically motivated purge threatening the stability of government operations. The directive created widespread anxiety among federal employees, with many fearing for their jobs and the continuity of essential public services. Legal challenges erupted almost immediately from federal worker unions and local governments, who argued that the president had overstepped his constitutional authority. These groups quickly mobilized, filing lawsuits in multiple jurisdictions and rallying public support to highlight what they saw as a dangerous precedent. Their central claim was that only Congress has the power to create, fund, or fundamentally restructure federal agencies. They argued that mass layoffs or reassignments, especially on this scale, without explicit congressional approval, would violate the separation of powers enshrined in the Constitution. The sight of empty offices and workers packing up their belongings became a powerful symbol of the uncertainty facing thousands of federal employees. Plaintiffs also pointed to long-standing civil service laws, which were specifically designed to protect government workers from political retaliation and sweeping purges. These laws, they argued, were meant to ensure a stable, non-partisan federal workforce, insulated from abrupt changes in political leadership. In May, Judge Susan Ilston of the Northern District of California issued a sweeping injunction, temporarily blocking layoffs at 21 federal agencies. In her ruling, she found that the president had bypassed Congress's constitutional role, raising serious questions about the limits of executive power. The administration, led by Solicitor General D. John Sauer, countered that the president possesses broad authority to manage the executive branch. They insisted the order did not violate any laws, but rather directed agencies to act within existing legal frameworks, emphasizing the need for flexibility and efficiency in government operations. When the case reached the Ninth Circuit Court of Appeals, the panel refused to pause Judge Ilston's injunction. This decision left the administration with few options, prompting an urgent, high-stakes emergency appeal to the Supreme Court. Now the case arrived before the nation's highest court, where the justices would be asked to weigh in on the fundamental balance of power between the judiciary and the executive branch, a question with far-reaching implications for American governance. At stake was a pivotal question: can a president unilaterally reshape the federal workforce, or must such sweeping changes always require congressional approval? The outcome would not only affect thousands of jobs, but also set a precedent for the limits of presidential power for years to come. The Supreme Court responded with remarkable speed, granting the administration's emergency request in an 8-1 order. This rare and decisive action underscored the urgency and high stakes of the case, as the justices moved quickly to address the administration's concerns. The order was issued late in the day, catching many legal observers and the public by surprise, and immediately shifting the national conversation. The majority of the court did not provide a detailed written opinion, explaining their reasoning. Instead, their silence spoke volumes, suggesting they believed the administration's arguments had significant merit, and that the lower court's injunction could cause real and immediate harm to government operations. Legal experts noted that such a move, without a full opinion, is unusual for a case with such broad implications. Justice Sonia Sotomayor wrote a brief concurrence, emphasizing that the executive order at issue required agencies to act consistent with applicable law. Her note hinted that the lower court's injunction may have been overly broad, potentially restricting lawful government action. Sotomayor's words suggested a careful balancing act, acknowledging the need for judicial oversight, but also recognizing the executive's authority to govern within the law. In sharp contrast, Justice Ketanji Brown Jackson issued a powerful and scathing dissent. She accused the majority of enabling what she called an unprecedented and unsanctioned dismantling of the federal government's ability to function. Jackson's dissent was not just a disagreement, it was a warning about the consequences of the court's intervention at this stage. She warned that by overriding the careful findings of the lower courts, the Supreme Court was allowing potentially irreversible damage to essential public services and the people who rely on them. Jackson argued that the court's decision could disrupt the daily operations of federal agencies, leaving both workers and the public in a state of uncertainty. Jackson's dissent highlighted a deep and growing divide within the court over the judiciary's role in checking executive power. She also criticized the increasing use of the so-called shadow docket, the court's practice of making major decisions without full briefing or oral argument, for cases with sweeping national impact. The majority's silence stood in stark contrast to Jackson's passionate warning about the rule of law and the future of American governance. Her dissent raised questions about transparency, accountability, and the long-term effects of the court's approach to emergency cases. With this order, the Supreme Court set the stage for further legal and political battles, leaving the nation and its government awaiting the next chapter in a rapidly evolving constitutional struggle. The Supreme Court's order is procedural, not a final ruling on the legality of the layoffs. It lifts the injunction, allowing the administration to proceed with reduction in force plans while the lawsuit continues in the Ninth Circuit. Federal agencies can now move forward with layoffs, leaving thousands of employees vulnerable and raising concerns about disruptions to public services. The legal fight isn't over. The Ninth Circuit will still decide if the president overstepped his authority. The order doesn't affect other lawsuits challenging specific layoff plans, such as those at the Department of Education. The court's move shifts the battle from broad injunctions to targeted challenges against specific agency actions. Justice Sotomayor's concurrence suggests future lawsuits may need to focus on particular layoff plans rather than the executive order as a whole. This order signals a new era in the struggle over executive power. By deferring to the president, the court may embolden future administrations to take bold, unilateral actions to reshape government. The ruling lowers the barrier for sweeping policy changes via executive order, even when Congress hasn't explicitly authorized them. The case isn't about the Second Amendment, but about the scope of presidential authority and the limits of judicial intervention. The decision also continues a trend of limiting nationwide injunctions by lower courts, pushing opponents to pursue more targeted legal strategies. Congress may now need to write laws with greater clarity to constrain executive action. This case will be a key reference point in future battles over the limits of presidential power. In summary, the Supreme Court's emergency order has dramatically reshaped the ongoing confrontation between the president and the federal civil service, marking a pivotal moment in the evolving relationship between the executive branch and the institutions that support it. This decision is not just a legal technicality. It signals a shift in how power is distributed and exercised at the highest levels of government. By lifting the injunction, the court has cleared the way for mass federal layoffs to proceed, a move that could fundamentally transform the government workforce as we know it. Thousands of federal employees now face uncertainty, and the ripple effects may be felt across agencies and communities nationwide. The decision raises questions about the future of public service and the stability of the civil service system itself. The ruling is widely seen as a major victory for the White House's expansive view of executive authority, granting the president greater flexibility to reshape the federal workforce. However, it's important to note that the core legal battle is far from over. The underlying constitutional questions will continue to be fiercely debated in the lower courts, and the ultimate outcome remains uncertain. Justice Jackson's forceful dissent highlights the deep ideological divide within the court and underscores the high stakes for the separation of powers. Her concerns reflect broader anxieties about the potential erosion of checks and balances and the long-term implications for American democracy. At its core, this case tests whether the civil service will remain a stable, professional body dedicated to serving the public or become a tool for presidential reshaping and political influence. The outcome could redefine the very nature of government employment and the expectations placed on public servants. The court's order, allowing layoffs to proceed now, while leaving the ultimate legal question unresolved, creates a new precedent that will influence policy debates and legal strategies for years to come. Lawmakers, advocates, and government employees alike are watching closely, aware that the stakes extend far beyond this single case. As the government moves forward with its plans and legal challenges continue to unfold, this case stands as a crucial bellwether for the future of American governance, the balance of power, and the enduring strength of our democratic institutions.